Okay.
Sorry for that.
Thank you very much, Pietro. Thank you for organizing the conference and for inviting me. I'm very pleased to be here. I'm just go through a little bit what I'll be talking about this morning. Surveillance culture, legal aspects and the concept of privacy, some methodology, which is framing. I'll talk about a little bit about the Snoopers Charter debate and then conclude. I should say, beginning, that I'm a linguist, and so my interest in this topic is really from a linguistic point of view. It's a socio-linguistic point of view, but I'll be toning down, I think, the linguistic analysis in this talk and maybe focusing more on the philosophical and legal aspects, which I think we all have in common. So, well, what to say? Our society is acculturated to and saturated with surveillance, and I think this is it's a topic that is constantly in rapid evolution. I've been aware of the issues for some time now, but it's just galloping. It's getting out of all control, and it's increasing exponentially. So I thought a good starting point would be with George Orwell. I mean, many things begin with George Orwell, also in critical linguistics. But the idea of 1984, the idea that Big Brother is some way watching you, that in Orwell's dystopian world of totalitarian government, there really was no individual space. There was no individual privacy. If you remember, in every home there was a telescreen, and people have to stand in front of them. The government brainwashes the citizens through this constant the messages that are being sent. And this is being paid for by the government, of course. This is a government business. In 2021, what's the picture? We have smartphones. Each of us has a smartphone, and our personal information is routinely disappearing into cyberspace to be picked up by companies and governments, potentially. And of course, we are responsible for funding this empire of surveillance because we queue up to buy the latest digital devices. And social media sites are brainwashing us into this corporate consumer capitalism. In cinema today, we have these fictional dystopias, such as a couple here, Will Smith's Enemy of the People. I'm sure you've all seen also The Circle. So in these films we see, and there are many others, we see the potentialities, the wonderful potentialities of high-tech gadgetry, but also the dangers for individual privacy and freedom. And so what about this? The idea that your iPhone, your smartphone could transform itself into a surveillance device for governments potentially, but also hackers and also powerful corporate bodies. And if you are interested at all in the possibilities of surveillance, you've probably realized that your PC can become used by hackers to spy on you. Potentially hackers could be criminals, but they could be the government. And so there's this recommendation on the internet that you put a piece of sticking plaster over your webcam. But why is it not possible to buy a PC with a plastic cover for this vital feature? It seems that almost the possibility of surveillance is being built into your gadgets. Well, one of the key moments in the recent past when these issues emerged was the Edward Snowden whistleblowing. He worked for the CIA, the National Security Agency, I'm sure you know. And in 2013, he became a whistleblower. He published a lot of his a lot of private material that in the Guardian newspaper in 2013, and he talks about his work in these agencies, and there would be these massive rooms with lots of techies at their computers doing this spying work, and every so often they would come across an erotic picture, perhaps, of some housewife or some private citizen, and he said that they would call the others over and have a look at it and a laugh at it, and he became very concerned about the dark possibilities of this technology. And at the bottom here, he says, I'm sitting at my desk and I could wiretap anyone, from you, your accountant, a federal judge, or even the president. You would just need a personal email. And this was denied by American officials, but it turns out that there is this technology that they were using called X-keyscore, and really it's very, very simple for them. There were no requirements for them to, there were no legal blocks, no court that needed to okay this surveillance, no NSA, no NSA procedures to go through. Well, the question is whether privacy is a legal concept or a personal matter. And here I'm not going to be, I'm sure that you know much more than I do about the legal frameworks, so I won't say much about that. But the idea, of course, is that legally we have this right to individual privacy, but against that there is this the balance. We have to balance the interests of the collective for protection. If you go back to some basic foundational ideas about democratic societies or societies in general, we have the notions from Hobbes, from Locke, that to exist in a society means to concede certain personal rights that we have to the state. And in return, of course, the state protects citizens from criminals and terrorists. But in the digital age, is it possible for us to be sure that the state is actually acting in the public interest, or whether modern surveillance methods criminalize citizens and put in place structures that could facilitate totalitarianism? And it's interesting that one of our participants this morning is from China, where I think expectations in this area are completely different than they are in the West, yes, in Italy, in England. So privacy as a concept it's quite interesting also that Italian doesn't really have a notion of privacy. It seems to be an Anglo-Saxon concept in some ways, but it emerges with the decline of the royal courts and the rise of bourgeois societies, middle classes in Europe. So we have the house become the personal house becomes divided into spaces where there's the private space at the back and the public space at the front. We have the emergence of new cultural forms, letter writing, diary keeping, the novel, romantic poetry. And so what happens is that the individual self becomes a thing. It becomes existence. It's the idea that we all exist as personal souls, as individuals, is consolidated through the Enlightenment and into our own day, of course. And so privacy becomes an important aspect of that autonomy and personal freedom. And so in the digital age, the question of sitting on a park bench, as here, reading a book, you might say, well, this person is in a public space. So what about where does privacy come in here? But supposing somebody took a photograph of that person or in that park, in 2 seconds, that image could be uploaded onto some social media and spread around the world potentially. Does the person have a right to privacy in that sense? Some kind of control of their image rights in some way? But also, it's not just about the individual soul. Surveillance is a question of collecting data. There's this a notion of big data. So when you park your car somewhere, your car might be caught on a surveillance camera, and the typology of the car, your shopping habits, your driving habits, and these things are collected without your consent or knowledge and used in things like credit scoring, social sorting, border controls, security procedures of various types. And is that okay? This is another potential legal area. The Internet of Things is a new development, very much. These days, our fridge, our microwave, our car, many objects that we have around the home are digital. And this creates convenience for us, but there are also the potentialities for these objects being linked up to some satellite and becoming potential bugging devices. Recently, this is one example of this is Ring, which I'm sure some of you know about. I'm sure you know about, but 2020, this Amazon engineer said it's just not compatible with a free society. What they do is you install this Amazon device as a citofono, to a ring. Somebody rings, and it's all internet, it's all digitalized, and so you have these ideas of who's coming into your house, but the device is programmed so that it can communicate with other Ring devices, and not just other Ring devices, but other digital devices. So potentially these things form a surveillance network. Again, not the role here of not just governments, but of big private corporations in this. And there's a collaboration between them and the police as the police use these data. Well, I'm going to rush. The methodology I'm using here in the actual linguistic part is framing, and I'm sure framing is something that's familiar to you all from your research fields. To frame is to select some aspects of a perceived reality in such a way as to promote a particular problem definition, causal interpretation, moral evaluation, and/or treatment recommendation for the item described. So this is a linguistic tool that we use to analyze linguistic data regarding these problems. Well, let me just explain a bit about framing. If you called something Frankenstein food, as was used back in 2013 to talk about genetical modification, well, you frame it as something bad. It's monstrous, potentially, because of the connotations of Frankenstein term. Likewise, a swarm of people, this were like a swarm of insects. These are is a frame, a negative frame for talking about migrants. And yesterday, actually, in the Russian section that I attended, Bill Bowrig mentioned Theresa May calling the European Commission on Human Rights a terrorists charter, which is another frame, of course. Trump used lock her up, which is a criminal frame, so suggesting that a political opponent is a criminal, and so on. Well, in 2016, the British government decided to introduce this legislation, Investigatory Powers Act, which introduced new powers for the British intelligence agencies. It created a commission to oversee investigatory powers. There was this requirement for a judge to review warrants for it. But the central idea was that communication service providers had to retain internet users' data for 1 year. So your browsing history can be watched for 1 year. And it allowed also police and intelligence officers to see internet data without a warrant, okay? So this was rapidly called the Snoopers Charter. And the Snoopers Charter, of course, is a frame. And yeah, this was by Theresa May, the government of Theresa May. So what is to snoop? To snoop is what private detectives do. It has very strongly negative connotations. To call someone a snooper is to insult them. It's a sort of dirty business to spy on people, especially in their private lives, as the examples at the bottom. I don't mean to snoop, but is there something wrong? Okay. During the debate on the Snoopers Charter, the Investigative Powers Bill, Nick Clegg, Democratic leader, compares it to totalitarian Russia is the only country, according to him. And Snowden also weighed in on the debate. A vote in favor is a vote against you. Well, here is some of the data from the House of Commons debate. Conservative politician at the top saying Snoopers Charter is a misnomer. Would the measure not be better termed a security charter? Okay, so they're arguing here about linguistics. What we call something influences the way we react to it. So if you term it a security charter, then you highlight the protection element. If you call it a Snoopers Charter, then you highlight the invasive nature of this legislation. Of course, the SNP, just a Snoopers Charter, they use the frame and they exploit the negative connotations.
Sorry, Douglas, 1 minute left.
Oh, okay, you've cut me down.
No, okay. Try to.
Okay, I'm coming on to a conclusion, but yeah, okay. So yeah, okay, let me just see what I've got. So let me see, European Court of Justice rules that this is inadmissible. They throw this out in 2016. They say that only the objective of fighting serious crime is capable of justifying such measures. And they also say that it cannot be considered to be justified within a democratic society. And of course, Britain has since left the European community. And so they can do what they like. So just to come on to a conclusion, I guess, as I said, I wanted to highlight, I suppose, the philosophical aspect of this. How do we think? This is a situation that is in constant evolution, and I'm sure that some of the things that I've mentioned here are familiar to you. Perhaps some of them will be new. But we are growing increasingly transparent to powerful corporations. It's not just government, it's also government, but it's also corporations. And they, at the same time, are becoming more opaque to us. We are becoming less and less able to have control over our futures. And I suppose my question would be, what do you think about that? How do you react to that? And what should we do going forward in a legal sense as well as a philosophical one? Thank you. Yeah, Beat.
Thank you, Douglas, for your presentation. Now, Vera Raposo has the floor, and she will present a paper whose title is "One App a Day Keeps the Virus Away. Digital Contact Tracing as a Tool to Handle the Pandemic." Vera, floor is yours.
Well, thank you so much. So indeed, I'm going to talk about digital contact tracing as a mechanism to handle the pandemic. And I'm going to discuss it mostly from a privacy perspective, even though there are other considerations that I think are relevant. So first of all, we all know we are living in a huge pandemic crisis, and in all pandemics, the keynote is to break the chain of infection. And in order to do that, you need to track people that are infected and immediately identify all the ones that have been in close contact with that person. And for that, you need to do contact tracing. This is not new. I mean, it has been used in many of the pandemics in the last decades and probably centuries. The difference is that back in the days, it was done traditionally by human operators. You will have healthcare staff that sit with the infected individual and will do a kind of an interview, asking with whom you have been in close contact. And then the person will identify all these other people. This is obviously not viable in our current scenario. First of all, this is a huge, like a worldwide pandemic. We simply do not have enough healthcare staff to deal with all these infected patients. Secondly, there is a specificity in this particular pandemic. The disease caused by the new coronavirus, you actually can be infected before the onset of the first symptoms. So it's very difficult to ask someone with whom you have been in close contact, going back to a moment in time in which the person not even knew that he or she was sick. And moreover, how are you going to identify all the people that you meet in the, I don't know, in the bus, in the shopping mall? You simply don't know the names. You don't know how to reach this person. So what you do is digital contact tracing, DCT for short, in this presentation. How does it work? So basically, you have an app in your smartphone, and if you are in contact, if you have been in contact with someone diagnosed as infected, you will receive a notification. This has to be a contact close than 2 meters. This is a close contact, and for more than 15 minutes. You also will receive an indication of how likely it is that you actually have been infected. This calculation is not done by human operators, it's done by algorithms, that is artificial intelligence. Of course, that simply receiving the notification does not necessarily mean that you are infected. So you will receive further recommendations on how to proceed. Like you need to get tested and you need to eventually quarantine for precaution. Well, in order to do all that, the app needs to deal with your personal data. And the problem begins because, as you all know, and actually Douglas already mentioned, in Europe, we have the General Data Protection Regulation, GDPR, which is, by all acquaintance, the most demanding and strict document on data protection worldwide. It is considered the state of the art in what regards data protection. I leave that open to discussion, but it is very demanding. And so it opens a huge amount of problems for governments that want to engage in digital contact tracing. So the first challenge is to select within the GDPR a proper legal ground. Because of course, if you want to process personal data, you need to have a good motive for do so. And you need to pick that on Article 6 of the GDPR. I picked some of the several legal grounds. There are more than these ones, but these are the ones that probably may fit our current situation with the pandemic. So 6.1a, of course, if the data subject consents. 6.1c, I think, could also be viable because it says that you can process data to comply with the legal obligation to which the data controller is subject. The data controlling meaning the entity or the legal person or physical person in charge of data processing. And I think this is viable if we conclude that the member states are obliged to prevent the transmission of cross-border infections under the so-called health threat decision. Also, 6.1d, to protect the vital interests of data subjects of another person, because in the end of the day, you are going to process the data to protect the interests of infected individuals and all the ones that have been in close contact with these people. But my favorite one will be 6.1e, if data processing is necessary in the name of the public interest, which I think is the case because, come on, a pandemic, how more public interest can it be? But the problem is not solved with Article 6 because the app works with health data, and more than personal data, these are sensitive data. And for that reason, they need an additional legal ground. Article 9.1 starts by saying, look, you cannot process sensitive data. But then Article 9.2 gives you some very specific circumstances in which you can process sensitive data, as it is the case of health data. So 9.2a, of course, consent, once again. 9.2g, substantial public interest, which I also believe it meets the situation. 9.2h also possible because it talks about preventive medicine. And of course, digital contact tracing is a way to prevent the transmission of the virus. But I will go with 9.2i, which is public interest in the area of public health. So similar to G, but focus on public health. Now note, consent can be a legal ground, both on Article 6 and 9. If you pick any of the other legal grounds, consent is not required, but still you can request it. I mean, it's not required, but you can go with the voluntary digital contact tracing. So what I'm going to do now is to analyze some of the features of the different DCT apps, because they are not all the same. They are different models, and of course, they raise different issues from a legal perspective. The first thing is you need to decide is, I'm going to use GPS or Bluetooth. So GPS, satellite global positioning system, tracks location. And so it collects information about the people's movements. Whereas if you use Bluetooth, well, you need to consider that Bluetooth is a technology for short distance data exchange. So it does not give you the location. It simply says that this device is nearby this device, but you have no clue where they are. Now, this basic difference leads to two important outcomes. One is related with accuracy. I believe everyone here has used GPS while driving, so you know that is not that accurate. I mean, accuracy on the GPS ranges from 5 to 20 meters, not viable for close contacts that go to 2 meters only. Moreover, as you all know, GPS only works in the outside, not indoors, and only if you do not have high buildings, otherwise it gets crazy. If you have a thunderstorm, forget it. So GPS is not that accurate to indicate a risky contact. Bluetooth is much more accurate, but still not perfect, because the Bluetooth sign, it can tell you that two devices were close to each other. But for instance, it does not tell you if the person that has the other device has some kind of protective equipment, like masks, gloves, which obviously will reduce the risk of infection. So the difference accuracy-wise is huge between the two models. But the most relevant one is the difference in terms of privacy. And this leads me to another question. Are we going to track proximity by using GPS, by using Bluetooth, or are you going to track location by using GPS? Well, proximity, as I just mentioned, only says that two devices were close to each other, not where they were. They can be in Lisbon, in China, wherever. We don't know. Now, what about location? Well, location gives you the exact latitude and longitude of a specific target in one specific time. It's very precise, so to say, in that sense. Well, you may say, what's the big problem of having my location? Well, in our current world, actually, our location is everywhere. Once again, I come back to the talk of Douglas. You know, telecommunication companies, they get your location. Various IT companies, they get your location, such as search engines, social media. Even many apps of your phone get your location. They ask permission to do that, and sometimes they don't ask, and they still get your location. So basically, location is everywhere. So what's the big problem of having a DCT using location? Well, the problem is that we should all be very worried with that, because location data, they are never really anonymous. Like, are you nearby a mosque? So maybe it shows that you are Muslim, or it shows your religion. Any other? Are you in a gay bar? It can show your sex orientation. Are you near the headquarters of a left-wing party or a right-wing party? It can show your political options. And maybe if you are here, you are cheating your wife. So you see, if people get your location, they get to know a lot about what you do and what you like and your preferences. And that's the reason why, just let me come back, that's the reason why European Commission, the European Data Protection Board, which is the entity that in the EU oversees all issues related to data protection, they do recommend to merely track proximity and not location. The other thing you need to decide when implementing a DCT is, are you going to use centralized or decentralized models? In a centralized model, all the data are gathered in one single source, which is a remote server, a cloud, and all the data are there. And though it is this remote server is going to combine all the information, analyze the information, and then inform the users of the app if they had been in a close contact. Differently, if you go for the decentralized system, most of the tasks and most of the information are carried out in your own device, not in the central source. It doesn't mean that you don't have a central source. Most likely you have, you still need it. But the majority of data and the most important tasks, such as analyzing information and notifying other users, this takes place in your own device. Well, I think needless to say that the centralized model is much more privacy friendly, because imagine in a centralized model, because you have that many information about someone in one single place, it's very likely that the individual gets identifiable because you have so many information about that person. Moreover, remember, all this information, all this data, and data, of course, they are very seductive nowadays. Data are the new oil, right? That's what they say. So because you have all this data in one single place, it becomes quite a temptation for hackers to simply go there and steal the data, or even for health authorities, governments to misuse this data, to redirect all this data to a different purpose. So if you think on privacy, you will go for the decentralized model. However, there are also some good reasons that may suggest the centralized model. You see, in the centralized model, because most of the information is in one single place, you have more scientific data that you can use in order to, I don't know, create a new vaccine or new ways to deal with the pandemic. Furthermore, it gives health authorities more control on how the pandemic is being handled, mostly about which people are being notified. Because in the decentralized model, health authorities have no clue of who has been notified and if these people are in quarantine or not. So they kind of lose a little bit track of what's going on with the pandemic. So you need to decide, if it was up to me, still I will go with the decentralized model, which is also the one that has been recommended by the European Commission and the European Data Protection Board. And finally, you need to decide if it's going to be mandatory or voluntary. Both the European Commission and the European Data Protection Board have recommended the voluntary solution. And I have here a quotation from the European Commission in which they say, they say something very interesting, because they separate the app in two moments. One is to download the app and activate the app, and the other is having the data being processed. And the Commission basically says, look, both these moments, both these actions have to be voluntary. You need consent. And this is interesting because the first moment, downloading the app, activating the app, well, it has to be voluntary. You cannot have it, you cannot force people to do that. You can eventually have a kind of presumed consent, implicit consent, but you do need some kind of consent. Whereas for the second part, which is data processing, as I just demonstrated, you can have consent if you pick 61A or M292A as the legal ground, in which case it has to be voluntary. But if you pick any of the other legal grounds, actually it doesn't has to be voluntary. It could be mandatory, at least in theory. Well, I think most people would say, let's have it voluntary. We should all agree on that. There is a downside though, because voluntariness can jeopardize the purpose of DCT. I mean, if people can decide to use it or not, I think most people will decide not to use it. And if that is the case, you cannot deter the chain of infection. One thing that you could do, as you have it in Macau and in China, is to have a kind of fake voluntary, which means that it's voluntary, but it is required for so many activities in your daily life, such as going public transportation, going to your school, even going to a shopping mall, that in the end of the day, it is actually mandatory. You could do that.
Sorry,
but
Vera, 5
yes,
minutes.
5 minutes. You could do that, but the European Commission already clarified that someone that does not want to use the app cannot have any negative consequence. So actually, you cannot do it. My suggestion will be to use the so-called opt-out model. So you have two models. In the opt-in model, you need a proactive conduct from the data subject in order to have the data processed. Whereas in the opt-out model, that happens kind of by default, and the data subject has to take an active conduct and say, no, I don't want my data being processed. And I think this will be good because it encourages people to do the right thing. Well, assuming that using DCT is the right thing, as I believe it is. But what I want to demonstrate with this is that people tend to go with what is already established by the fact. It's to ask a human being to do something, to take an active conduct, is simply too much for us humans. And let me give you an example. Singapore. If you ask me a jurisdiction that is very likely to use DCT, I would say Singapore, because they have a very techno population. I mean, Singapore in itself is like a city from the 25th century. And moreover, they are very used to state intrusions in private life. So they will be the perfect scenario for DCT. Still, only 20% of Singaporeans downloaded the app. Why? Because asking someone to do something, it's too much for humans. They need this additional help. There might be a problem with the opt-out model, though. It might not be compatible with the GDPR if you pick consent as the legal ground. Look, recital 32, it very clearly says that you need a very explicit consent. So silence, pre-ticket boxes, inactivity, it's not consent. It excludes the opt-out model, but only if you pick consent as a legal ground. And that's the reason why I suggest not to pick consent and to select any other of the possible legal grounds. And still it can be voluntary. You still request consent, but it's a more flexible consent in which you can use the opt-out model. And of course, DCT has been received with criticism in many jurisdictions. It does have several loopholes, I recognize that. Privacy concerns, I just talked about it. Data are extremely difficult to anonymize. And even if you use the Google Apple API, which is the most used protocol in Europe and I would say around the world, and I believe it's the most secure as it can be, still there are some privacy issues that can lead to discrimination and loss of opportunities. There are issues because when we start travel again, when will that be? There is the risk that the apps cannot communicate with each other because, I mean, they follow different protocols and they can be, they follow different norms on data protection. So there might be challenges on the transference of data to another jurisdiction. Of course, within the EU, it's not such a big issue because most of the apps from European countries, they follow the Google Apple API, so they can communicate with each other. Data can easily follow around the EU, not a problem. But the world is much more than the EU. And if you come to China, to go to Singapore, to the States, then you can have a problem. You can have what I have called in a paper of mine, a virtual Tower of Babel. The other problem is effectiveness of DCT. Many people say this is not reliable. It does not produce good results, so why bother? Well, effectiveness is related with the lack of reliable data. Bluetooth, even though very accurate, it's not perfect. Effectiveness is related with the low number of users. There is a study from the University of Oxford that set the path of 60% of users in order to have good results. Of course, after that, many other studies said, no, you don't need such a demanding threshold. Even low percentages, you can have good results. The Oxford team also recognized that. So even with, let's say, 20% users, you can have some effective results. But of course, the more, the better. So why people is refusing to use the app? Well, many things. They have the fear of battery consumption because you need to have Bluetooth on, which, by the way, is not true. Going online, you can see many scientific studies about that. Most of the concerns are privacy concerns. And that I found very funny because people don't mind to share the most private data of their lives in social media. But if it is to share with the state, health data, even sometimes not that private data, they get very concerned. And that is surprising to me. And I think the issue is because there is nowadays a lack of trust in governments. And in some way, a lack of trust in these private companies, Google and Apple, that develop the Google and Apple API, which we all know, they do have a kind of dark past in terms of privacy. But I mean, privacy is not the only value. Just go to GDPR. Recital 4 very clearly says there's more in the world than privacy. I mean, you need to protect your private data, but this is not an absolute right. And because of that, all things considered, that's the reason why I'm still an advocate of DCT. And because we already concluded that the pandemic is here to come, I think that's the only way you can have some kind of normality in the coming years. I leave you with some references of mine. I have been studying this issue in the past months. And well, thank you so much for listening to me. Thank you.
Thank you, Vera, for your presentation. Now, Julia has the floor. She will present a paper whose title is European Data Protection Spectrum, Testing the Free Flow of Information Principle on the GDPR's Market Side. Julia, please.
Thank you very much. So while I'm trying to share my screen, I just wanted to thank Vera for this wonderful presentation, and exactly what she says is a precondition of the part that I will illustrate. Because in this presentation, I will ask myself what happens to the data, also to the health data, which I will use as a test case once they have collected. How far can they be used for research purposes? And in light of this question, I just want to inquire the effectiveness of the free flow of information principle on the GDPR. As Vera concluded, also within the GDPR, or as the GDPR acknowledges, it's not only about a right to data protection, a right to privacy. The GDPR itself recognizes that there are other interests to be considered when it comes to personal data. And in particular, the GDPR poses a special attention to the issue of research. And this from two perspectives. First of all, we all know that the GDPR is centered on the notion of, on the basic concept of data protection as a fundamental right. This is acknowledged as it is enshrined in the treaties. And in the European Charter, of course, of Fundamental Right. But if we look closer at the wording of the GDPR and to its recitals, it clearly also states that the GDPR has also the other and further objective of enabling free flows of personal data within the European internal market. So there is a GDPR's market side. This is my first assumption, which has to be contextualized, of course, in the broader European policy regarding data sharing. We all know that with the European strategy on data, the European Commission calls for a greater reuse, for a greater availability, for a greater accessibility to data. So the question comes around, and also first regulatory interventions in this direction have been done. We all know that in November, the proposed Data Governance Act has been issued, which also sets specific regulatory mechanisms exactly for the purposes of the reuse and the sharing of data among different stakeholders. And in this broad European policy, the objective of sharing for the public good, that is, for the public interest in the issues. So in light of these declaration and policy and emerging regulatory declaration, the issue comes about what is the data protection stance in respect to these objectives. So how far comes the European data protection law in contributing to these general objectives of sharing, of reusing valuable information. And in this respect, the pandemic has also shown the crucial importance of availability of data, as Vera was mentioning, collected through various apps. Of course, this precious health information is to be reused, and in the pandemic, reuse of personal sensitive information as health data has been crucial, for example, for identifying in some geographical area and for predicting in some geographical area the spread of the coronavirus. The reuse and the analysis of health data, also not only of sophisticated health data as health data, for example, strictly coming from clinical trials data, but also that what the European Medicines Agency calls a real world health data. So health data that are commonly collected by digital devices. These data have been resulted to be extremely useful also for the development of the vaccines, which are sort of helping us to come out of this dramatic situation. So reuse of personal data, especially of health data, is crucial. It is welcomed and promoted by the European Commission in respect to this broad objective of building a European data space. And in this respect, we have to remember that the Commission is working on the construction of an outright European health data space, in which health data are supposed to freely circulate and to be reused by various both public and private actors. So in this context, in this scenario, what is the contribution of the GDPR? While the reuse and the accessibility of health data has been very much needed during the pandemic, there have been also some, exactly in these months, some strong critics by exactly researchers in the health sector, especially that have strongly criticized European data protection law, especially in respect to the lighter regime that is established by US data protection laws, because it is said that the GDPR, with its burdensome requirements, procedural obligation posed onto data controller, it is stated that GDPR ultimately hampers research and so valuable development in the field of health research. But how, and in particular, there have been a series of articles published on Nature journal, which directly hint and underlie the disorientation, it is said, by European researchers, exactly in respect to the problematic handling of personal health data under the GDPR, especially because it is said that the GDPR, in respect to research, sets a specific framework, which we will go into more deeply in a moment, but leaving economic operators with strong and heavy uncertainties about the effective impact of these regulatory requirements, and this uncertainty in turn impairs research. So on the one hand, there are direct obstacles to research posed by the GDPR itself. On the one hand, further problems comes about from the vagueness and the uncertainty that the GDPR leaves open when it comes to research. Now, under these premises, we must bear in mind that although it is true that the European Commission in its European strategy for data is calling to the openness and to the availability of data, it also sets a very important principle that is crucial also for reading the GDPR in light of these broader European data policies. The principle that must be referred to is the so-called principle as open as possible, as close as necessary. So the Commission actually has strongly in mind that availability and reuse of data cannot be unlimited, but it has also to respect some specific limits. And of course, when it comes to personal data, the first limit is given exactly by the provision of data protection law in respect to the processing and the further processing of personal data, and especially of sensitive data, with which object, of course, the ultimate object is to protecting the rights and freedoms of personal data subjects. And in this respect, we have analyzed, we have undergone a study with my professor Giovanni Comandè, with whom I'm working with, and this study is being currently published in the German Law Journal. we have asked ourselves the question, which are the limits posed on data sharing, on the reuse of personal, also sensitive data for research by the GDPR, exactly in light of this twofold nature of the GDPR, on the one, and these twofold pillars, the regulatory pillars of the GDPR, on the one hand, protecting the fundamental rights of data subjects, and on the other hand, of enabling the free flow of information of personal data, which is itself a standalone object of European data protection law, because as in every other European regulatory area, of course, the European regulators' aim is that of building the European internal market, and with this, the digital single market, and in which personal data, of course, have an important role. And exactly in light of these two different pillars, if one reads with greater attention the text of the GDPR, you can see that in respect to research, there is a dynamic spectrum of data protection regime, moving from a more data subject control to a more controller center regime. And in this respect, this is to be more precisely seen in respect to the regime of sensitive data under Article 9. We have indeed the exceptions to the general provision of processing health data offer legal basis for the processing of health data that, of course, have to be combined also with the legal basis, with the general legal basis under Article 6. But if we try to analyze these legal bases that work as an exception to the general prohibition of processing health data, we can see that they can be subgrouped into three main categories. On the one hand, there is a data subject-oriented regime given by the reason of processing through consent, the protection of a vital interest, the performance of an obligation, and the data that are manifestly public data. And there is also a data subject-oriented regime, exactly because if data is manifestly public, it sort of underlies the intention or the will of the data subject to render the data sort of public. Then we have also a public interest regime, which is given by public interest, public health, preventive medicine, and legitimate activities. And we have also a research-based regime given by the express provision under Article especially 9, paragraph 2, letter J, of the processing of health data exactly for research and statistical purposes. Now, under these legal bases, we can see these legal bases actually can be be illustrated according to this pyramid that you can see here, because the stronger, of course, the tying to the data subject of the processing is, the stronger are also the data subject rights under Chapter 3 of the GDPR, as the right to access, the right to be informed, the right to erasure, to rectification, and so on. While we go down the pyramid and we go and we move towards public interest-oriented purposes or research-oriented purposes of the processing, we see that the data subject is not there anymore. As Vera was pointing out a minute ago, public interest research is a self-standing, we can say purpose, and which does not require any input, any active involvement by the subject. And so it is for the research. And these legal bases, of course, enable the free flow of personal and also of sensitive information, But it is the interesting thing to observe is that while we go down this pyramid and we go towards a public interest or research-based regime, there are growingly heavy, we can say, a derogation to the same data subject rights, exactly so as to signal a progressive detachment from the data subject's sphere of control over its sensitive data. And for example, in light of, in respect to public interest oriented grounds of processing, Article 23.
Sorry,
exactly,
Julia, 5 minutes
yes?
left. 5 minutes left.
Perfect. Yeah, I'm approaching to the end. So in respect to public interest in processing ground, it is the same Article 23 that enables member states to provide for derogations to data subject right, exactly for the processing of personal data for public interest purposes. And the maximum derogation that we can see moving down the lines of this pyramid is exactly provided for the processing for research purposes. In this respect, it is the GDPR itself that provides for strong and heavy derogation from the data subject's rights, and it establishes under Article 9 and Article 89 the obligation onto data controller to implement safeguards, technical and organizational safeguards for the protection of the rights and freedom of the data subject, exactly for the counterbalancing of these derogations. And these technical and these normal legislative technique is exactly consistent with the purpose, with the pillar, we can say, with the regulatory objective of enabling the free flow of information, of personal information, also of sensitive information. So you can see that under this research-based regime that we can call, given exactly by derogation to data subject rights and to the obligation and responsibilization of data controllers to enact adequate measures, although enabling the sharing and the flow of these data, this data research-based regime is, we can say, an outright breach in respect to the purpose of protecting fundamental rights, exactly for the different purpose of enabling free flow of information. Of course, we say there's a requirement of establish adequate technical and organizational measures for the purposes of protecting rights, given under Article 89, but it is a self-regulation thing. So it is not the GDPR. The GDPR will say you have to do this, but it does not say how and what exactly to do. So reaching immediately to conclusions, we have observed that the GDPR is characterized by double fine-tuning systems across differential data protection regimes. So the greater the loss of individual control, so the greater the detachment from the data subject fear is, the greater the shift of burden of protection shifts onto controllers in terms exactly of additional safeguard under the Article 89 that I was just referring to. So this similar scaling among so the very last thing I want to say, of course, this research-based regime, although it is to welcome, of course, in light of the enabling nature of personal data flows, which are extremely valuable, especially in times of pandemic, it has to be better assessed because the GDPR says nothing about, for example, the distinction between the distinction between public interest or rather commercial interest research. And this is quite problematic because this research-based regime actually enables, for example, big company to reuse infinitely data, also sensitive data, for the purposes, for example, also of commercial research. So we see a need of distinguishing and of further fine-tuning this free flow of information regime under data protection law in light of the further distinction between for-profit and public interest regimes. And we see that in light of this further specification of the research-based regime grounded on in an interpretative basis, because the GDPR actually only says that the research is to be intended very generally and so as to comprise also commercial research, we see that under this interpretation of a more complex interpretation of the research-based regime under the GDPR, we argue that the public interest-based regime, so processing activity for public interest purposes, should greater benefit from a facilitating and an enabling data protection regime. And the GDPR actually gives a strong indication towards it, so as to favor, towards the possibility to favor public interest-based research activities and to restrict a bit research for just commercial and for purely for-profit purposes. And this distinction, I think, is extremely important exactly in light of the current needs of processing health data, which the pandemic, of course, have exacerbated. I thank you very much for your attention.
Thank you, Julia, for your presentation, and I thank you, the committee, for having given me the possibility of acting as a chair of this really interesting session. Now the floor is open for questions from our participants to our speakers. So who wants to ask some question, please, is asked to raise his or her hand. The floor is yours. Well, if there is no question at the moment,
Luciana has a question. Yeah.
Sorry?
Yes.
Okay. Okay.
Sorry, I cannot open my webcam because I have bad connection. So I want to make sure you hear me clearly. And do you?
Yes, okay. We can hear you. Yes.
Okay, thank you. First of all, I want to thank all the speakers today for their amazing presentations. Very, let's say, enlightening for me. And second of all, I wanted to, let's say, leave a comment on what Professor Douglas Ponton said, and maybe add an example that can enrich his presentation. Yesterday, so I will link fiction and facts like I did by talking about Orwell and movies and also real stories, let's say. And yesterday I watched the first episode of the TV series on Disney Plus, Loki, and the main character, Loki, was called in trial, and before entering the trial, he was asked to, and I quote, "sign every word you ever said." And there was a printer that, in fact, printed all the words he said in his life, a very big file. And indeed, he asked what, and a new sheet had to be signed for his last word. And it reminded me of a case in Arkansas, if I'm not mistaken, because the Amazon aqueduct was considered to be a witness to a murder by a prosecutor, and Amazon denied access to the information, to the recordings for this case. And I was just thinking that I can't believe that Amazon actually protected the privacy of a citizen against, let's say, the state, which should be, I'm not saying a protector of the citizen, but giving some rights and rights for privacy and all of that. So it's very weird to me, and telling maybe of where we are heading to. Like, are we really going towards a point where we will sign even digitally every word we've ever said? So just a comment. Thank you so much.
Thank you. Can I say something, Biagio, on that? Thank you. Yeah, no,
Sure.
very interesting. I mean, there are some people who say that we might be living in a computer simulation. This is a sort of philosophical idea from modern thinkers, which is becoming less ridiculous as time passes. But I was thinking of saying that I have a friend who's working in emotional face recognition technology, and yesterday he showed me a film. These technologies are being rolled out actually in China. Perhaps Vera can tell us something about this. That apparently these systems, which are robotics and also high tech, are able to tell from your face, your movements, your body, your emotional state. And the point about this is that you will have to be, if you work in a corporation, you will have to be not just a great worker, not just productive, you will also have to be a certain emotion. You will have to be happy, you have to be outgoing, positive, this kind of thing. And so this is, I think this is, for me, it's highly dystopian. I like to think of myself as this sort of enlightenment individual, a person with a private space, which the emotions are very much part of. And so the idea that a company, in this case, or a country, is able to pry, to snoop into your soul in some way, in inverted commas, because maybe it doesn't exist, is deeply disturbing. And so, I find these futures, which are, really, they're not distant futures, they're sort of rapidly approaching futures, and they might be here in some contexts of the world. So I just wonder if Vera has something to add about that in China at the moment, or what how you might react to that.
You have to unmute, Vera.
Sorry, I was so excited. So yes, I was thanking Douglas for the question. Well, China, by China I mostly mean the mainland, because I'm in Macau, the special administrative region. Yes, they are huge players in everything related with technology and artificial intelligence. As you know, for a start, they have the social credits in which all behaviors of the citizens are assessed either for good or for bad, so they can give you credits or take you credits, and this is then relevant for various decisions, such as if they get a visa to go abroad. We do not have that in Macau. As you know, we have a different system, most likely to disappear very soon. But doing also the follow-up on what you said, the very notion of privacy here is completely different. There is not a notion of the private space and what is private. So many of the things that in the West raised huge outcry here are simply accepted as being normal and performed in light of the common good. This is, of course, it's because of the legal regime, of course, the Communist Party justifies everything, but also there are very deep philosophical reasons based on Confucianism and the idea that the community always prevails over the individual. Changing just a little bit the scenario, the geographical scenario, and coming back to Europe, I'm sure that most of you have been following the recent proposal of the European Commission on artificial intelligence. That has, well, I think these for us, well, lawyers, ethicists, all these people interested, this will be the topic for the next few years. Facial recognition, I'm very interested in that. Of course, that is the one that Douglas said, how they can scan your emotions. Actually, stores are already doing that. They redirect you for different parts of the store according where you are showing that you like the product or not. In China, by the way, you know, yet you can pay with your smile. I think it's Kentucky Fried Chicken if you allow it. If you allow it, they say. They get your biometric features, and then instead of paying using money or whatever, you simply smile, look at the camera and smile. By the way, in China, I never carry my money. We pay, especially now with the pandemic, all our payments are doing with that. And which, by the way, it's also, I know there's privacy issues, but you cannot imagine how convenient it is if you try to pay a taxi with a $20 bill and they say, oh, I don't have this is very convenient. Of course, privacy issues. But coming back, I think the proposal of the Commission that covers, I don't know, deep fakes, use of facial recognition for so many, in so many scenarios, especially for law enforcement proposals, which is also being used in China and in Russia to control the pandemic. Everything, I think, in terms of privacy, this will be a huge topic for the future within the EU.
Yeah, if I can jump
yes,
on that.
Julia. Yes.
No, I find it extremely interesting what you were saying, Vera, and especially on the topic on surveillance. I just had two remarks. The first is that really new surveillance tools are emerging every day. I think just about the e-proctoring systems that have been employing by university for surveillance purposes now during the pandemic. And we can foresee maybe that this will not just be an emergency measure, but that will also go well beyond the pandemic. And this, of course, triggers question about new forms of intrusiveness exactly by private companies on our daily lives, also on our activities that we cannot but do, as taking exams for university. And related to this, I think that the proposal for regulation on AI actually doesn't actually capture this point, because if you read it clearly, it says it adopts a Chinese-based approach in the sense that, or a counter Chinese-based approach, because it prohibits any tool of any artificial intelligence systems that conducts social credit scoring or facial recognition by public authorities. So it is like the European Commission says, we don't want to do as China is doing, but it does not actually considers, or it does not regulate as strictly as those public employment of artificial intelligence by private companies. So if a company, a private company that social scoring, or it is private companies that conduct facial recognition, it is still possible. So of course, it will be considered a high-risk system, so it undergoes a lot of procedural obligations and so on, but it's still possible. It's not prohibited. So it is that the European Commission is approaching the topic from a Big Brother perspective, of a traditional Big Brother perspective, but not from an up-to-date, we can say, perspective where it is private companies that conduct also very important public tasks as surveillance and also recognition activities. Think about the case of Facebook facial recognition. And it does not take also into consideration a reality that it is at present of increasing private-public partnerships, where it is the private sectors that handles an enormous amount of data to the public. So it actually is a void provision, the prohibition by public authorities. Of course, it is still important. I'm just sort of approaching it critically, but public authorities are still free to buy all the information or receive all the information by private companies, and the outcome is very much the same. So these are just a few thoughts on the regulation on AI and on the issue of surveillance.
Thank you, Julia, for the questions to our speakers. Yes, Bruno, please.
Thank you very much. Just a quick question. I think that dealing with privacy, we can kind of distinguish the vertical relationships between, the citizens and the state, which the speakers today really inquired in a beautiful way. And so to say, the horizontal relationships between citizens and companies. And usually when we try to measure the effectiveness of a legal regime, we start from sanctions and from consequences. In English law, people would say that first we have the action, and after that we have a right. So when we were like teaching privacy or dealing with privacy on a professional level after the GDPR became effective, we really, at least in Italy, tried to carry out some psychological terrorism. Say, the sanctions are very high, 10 millions up to 20 millions. But then my idea, I'm not an expert, is that in Europe, the authorities and judges have started a bit slowly to award compensation from that for damages and other measures, sanctions in general. So my question is to all the speakers, do you think that we have nowadays in the horizontal relationships a good balance between the rights and the consequences of the violation of the rights in Europe and outside Europe, something which I really don't know. And that links the issue to the artificial intelligence new provisions, as they are based very much on a tricky regime of liability. Thank you very much.
Douglas,
Can I say something which is really, Bruno, thank you for the question. It's really not an answer to the question, but it's sort of to ride on the back of your question, and then I'll ask the experts to comment, because you know, I'm not a lawyer, but I'm very interested. I think one of the problems of the area of surveillance and privacy is that it's possible for a company or a government to be spying on you, maybe for years, and you won't know about it. It's something that it's very difficult for the individual to know that this thing is happening to you. It's very difficult to know exactly how you obtain redress for it. So it's also something that when you click on accept on an app or on a program, you say accept. What are you accepting? Have you gone through the 10 pages of small print that go? Of course you don't. Life is too short. And so maybe you've given up by clicking there. You've given up your rights to any kind of redress, and you've actually signed away your bank account details, your name, your address, your fiscal information, all that kind of stuff. You've given it away in the first place. So I think, just to ride on the back of your question, you know, maybe our experts could think about giving us the legal positions there. Thank you.
Julia or Vera, want to add something? Yes, Vera, please.
Well, I have a very non-romantic vision of the GDPR. It's supposed to be the state of the art. Actually, it's, I don't know, it's a whole bunch of norms, allegedly very detailed, too much detail for the companies. Because when we think about companies and when we think about the protection of personal data in horizontal relations, as Bruno referred, we tend to think about, I don't know, Amazon, Google, Facebook, all these giants, and they are the dark side. They are the dark side of the business world. But you need to remember that the GDPR applies to everyone. In those small companies, they have a small store, they have, I don't know, small companies that fight immensely to comply with the very demanding standards of the GDPR. Some of them are totally unreasonable for their kind of business. And I'm not sure, I think it remains to be seen if personal data are actually being more protected with GDPR. I'm not saying no, I'm saying it remains to be seen. I don't have specific evidences on that. I think for companies, look, the Amazons of this world, they always can pay the top lawyers that manage to get inside the gray areas of the GDPR, and God knows how many gray areas they have. Everything is gray on that. And they can pay, they can pay to these lawyers can go around, even if they, first of all, they hardly pay the penalties because they have the good lawyers that can play with the GDPR. And when they pay, come on, it's Google, it's Amazon, it's peanuts for them. And then you have the small companies, and those business probably will perish, overwhelmed with so many regulations. Because it's not only the GDPR, the EU is overwhelming us with so many regulations. With the idea of the digital Europe, of course, very fancy, I'm all into it, but so many regulations, it's simply too much. It's a diarrhea of norms. And now even the proposal on artificial intelligence, I want to see which company in Europe is going to dare to develop any product on AI, because it's simply so many regulations and standards, they will all fail, whereas the rest of the world will create incredible whatever, but business will flourish, not in Europe. And you know who wins with that? Lawyers, because please, the ones that know how to play with the GDPR, they can make fortunes. And you can see now law offices that have all these specialists in GDPR. It's a business. This is purely a business privacy. Sorry for my.
Well, I think that a really good subheading for this session is, where are the balance to be struck? Because you are dealing from different angles with conflicting values, cultural values, or conflicting legal interests. So I think that a good subheading would be that. And I have a very short question. I know that we are running out of time. We have 2 or 3 more minutes left. So I try to be within the time. But if Douglas dealt with different cultural values, so according to you, in your opinion, would be room for a dialogue, because difference, cultural difference might be immense, might be really significant, and this difference, this distance between culture could hinder an effective dialogue on the ground of privacy or privacy. You prefer privacy, I know. I remember a quite seminal article by James Whitman, about the different cultures, different privacy cultures. And
Yes.
The problem is that the technical ground resents of and is deeply entrenched on the cultural differences and the cultural values. So is this dialogue possible for you? It's $1 million question.
Well, I think in terms of, I've done some research with Russian. I know we have Christian online with Russian, different notions of privacy, and again the same kind of dichotomy that we find between this Western idea of the soul and the Chinese or the Russian. It's a more collective. The privilege is the collective dimension. But I think, in terms of intercultural research, I think it's certainly a possibility and a rich area of study. But I was chatting with Vera about China, about the idea of, I find it's fascinating, the idea that the Chinese people just have this kind of acceptance of the common good, and okay, it doesn't matter. We don't have any individual rights. We don't have any privacy. We don't have an individual soul. We're just like little ants. From a Western perspective, it's a strange and alien concept. And I was asking Vera if Chinese people who come to the West and integrate in our societies, if they develop, a more Western attitudes in that respect.
And going on the ground of dialogue, I addressed this question to Julia and Vera. Who do you think possible to have a real effective dialogue among different social sciences expertise? Because this session has put together side by side different expertise. So to which extent the expertise of all the social sciences, other different than lawyers, may help, may foster legal reforms and contribute to improve the condition, the situation of law, as to privacy, of course.
No, thank you, Biagio, for this question, because this is a quite different point of view from the now dominant one that claims that law has to increasingly dialogue with engineers, software developers, data scientists. No, so from other scientific disciplines that are not social sciences related. So actually, this is a great insight on how other disciplines, other than different from the technological related one, can contribute. I personally have never thought about it. I mean, I think that also political studies surely should play a greater role, also because, of course, that what I was saying before, that there is the intention of the European Union to distinguish itself from other players, other big players, but the results of this intention concretely, that is concretely enshrined in law, are then doubtful in respect to their efficacy. And I'm addressing this thing to Bruno, which was exactly pointing at the adequacy of the sanctioning and the deterrence aspect. And I think regarding this, there should be greater proportionality in respect to the size, to businesses, and this is not a thing that is quite very much embedded into law yet. And also when there is a proportionality objectives or criteria that is applied, as in respect to competition law sanctions, these remain still quite ineffective, and the sanctions that are produced are still not enough. I mean, the Google, the Apple case, the fines exactly show that. I mean, although it sounds a lot, that what they have to pay for them, it's not. So, but in respect to the other social science, I personally don't have an answer yet to this. But great insight. Thank you.
And Biagio, I just said that I've just posted in the chat a link to this CRIL, which is a Center Group for Research in Language and Law. So there's in Naples and Caserta, there's a study group, which is it's linguistic aspects of law, and there are some great legal specialists who come, and great linguists who also come, and there's some dialogue going on there, and it's fascinating area of research.
Yeah, I mean, I think that the linguistic perspective is increasingly crucial if you think about all the discussion about the notion of interpretability, explainability of technology. What does it really mean? And still there are many critiques also in respect to the proposed regulation, that it uses unclear, vague terms, again, in terms of what is human oversight, for example, the new requirement under the proposed regulation. So a greater work from a linguistic perspective would really be useful in respect to the right choice of the right terms.
Well, there's an area of linguistics called forensic linguistics, which is, in terms of exactly that, the role of language in and the precise meanings of specific words and so on.
Okay. Unfortunately, we came to the end of the session. It was probably too short. This is my opinion, of course. I again thank all the speakers for their very interesting presentation. Douglas Ponton, Pera Raposo, Julia Schneider. I thank the Juris Diversitas committee and the participants to this session. See you soon. Thank you.
Thank you very much.
Yes.
Thank you.
Thank you.
Thank you very much. Bye-bye.
Bye.
Bye-bye.
Bye.